Hi, everyone, and thank you for joining me today for Glimpses of Hope Protecting Software Innovations After Alice. My name is Ashley Sloat, and Kristen Wolf and I together have put this presentation together for you today. So enjoy. First, we have a brief introduction into Aurora and Section 101 of the U.S. Code. Then we will discuss relevant software patent court cases as well as some application drafting tips. And then please join us for part 2 of this, where we discuss alternatives for protecting software innovations. So we'll begin with an introduction. So Aurora Consulting is a patent strategy firm who helps early stage startups and companies navigate the patenting process. We help them develop a patent strategy and then execute their patent strategy. And this includes anything from drafting patent applications to prosecuting patent applications, maintaining of the portfolio long term, as well as marrying the business strategy with the patent strategy. So, and together, Kristen Wolf and I do all of the client-facing work. So very likely if you come to work with us, you will see our faces. So with that, we will move into subject matter eligibility. So as a reminder, what constitutes patentable subject matter? Let's review USC 101. It states, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. So basically, if you invent a new process, machine, manufacture, or composition, or any improvement of one of those, then you can obtain a patent. However, the court system has held that this provision contains an important implicit exception. Laws of nature, natural phenomena, and abstract ideas are not patentable. And you'll note that the statute does not say this, and I would argue that had Congress wanted it to say this, it would have said it in the statute. But in this case, the court system has read into the statute a little extra, and that extra is this implicit exception. And this came about during the Mayo versus Prometheus Labs case in 2012. And now this has kind of permeated also into the software space. So what does our subject matter eligibility test now look like post-Mayo and post-Alice? Well, it's a two-step test to determine eligibility. Step 1 is basically claiming the 101 statute. Is a claim directed to a machine, process, manufacture, or composition of matter. And as many of you can guess, software is directed to a process, machine, manufacture, or composition. So the statute as originally composed does include software, I would argue. However, in cases where it is not a process, machine, manufacture, or composition of matter, then as you can see, this test moves immediately to not being eligible under 101. If it is a process, machine, manufacture, or composition of matter, you move to step 2A, which is reciting the implicit exception that the court system has read into the statute, which is determining if the claim is directed to a natural phenomena, a law of nature, or an abstract idea. And so many software claims have been deemed to be directed to an abstract idea, which has had them move from step A to step 2B. And in step 2B, we determine if the claim recites additional elements that amount to significantly more than the judicial exception. And what this significantly more has basically turned into is a 102 or 103 inquiry, where you basically have to prove that one or more steps or elements of the claim are not found in the prior art, which again is a 102 and 103 inquiry. It probably doesn't really belong in a subject matter eligibility test, but here we are nonetheless. And if you can prove that it has significantly more, it qualifies under 101. If you can't prove it, then it's not eligible. So let's review some relevant court cases now that we have the basic framework in our minds. First, we'll talk about Alice versus CLS Bank, which was the pivotal software case that led to software being included in that framework. Alice had claims directed to a method of mitigating settlement risk. And this is the idea that a counterparty fails to deliver a security or its value in cash as per agreement, or it's the risk that a counterparty fails to deliver as part of an agreement. And so what Alice did was use software to automate this process using shadow accounts and whatnot to try to mitigate this risk. And what the court found was that The method merely requires generic computer components, nothing more than applying it on a generic computer. They also stated that the steps were all conventional and that the claims were directed to a long-held economic practice. Traditionally, clearinghouses were used as the intermediary, and in the claims in Alice, it was actually shadow bank accounts and whatnot that were used as the intermediary. And so they basically stated that you're not really doing anything different than was previously known except automating the process, which I don't necessarily argue with. But I think it's more of an issue that the claims were drafted according to a different interpretation of the law. And had this framework been in effect at that time, maybe the claims would have been drafted differently and maybe Alice would be in a different place today. But who's to say, right? Next, we'll talk about DDR Holdings versus Hotels.com. DDR Holdings had claims directed to activating a link and displaying third-party product information on a composite website that retains the look and feel of the host website. So these were basic claims directed to the idea of retaining visitor traffic on a website. So instead of clicking on third-party product information and being transported to that third party's website or to some other website, a new website was created, a composite website that displayed this third-party product but also had the look and feel of the host website. So it made the visitor believe that they were still within the host website and allowed them to more easily stay on the host website or move back to the host website. And what the court found was that the patent sought to solve a challenge particular to the internet, and that was the idea of retaining visitor traffic on a website. And although Hotels.com argued that the idea of a store within a store existed, the court stated that that practice did not have to account for the ephemeral nature of an internet location or the near instantaneous transfer between these locations made possible by standard internet communication protocols. So the idea that, it's not like you can be transported from a Costco all the way over to a grocery store miles away by going to a kiosk in a Costco, which is more analogous to what is happening in the internet. You can click on a link and be transported to a completely different page and not really have an idea of how to get back to that page. And so what DDR Holdings did was create this way to keep visitor traffic on their website by creating these composite websites. And so this is definitely a step in the right direction. As you can see, they were again trying to solve a challenge particular to the internet, which weighed in their favor. Next, we'll discuss Enfish versus Microsoft. Enfish had claims directed to a self-referential table. Typically, computers use tables that reference each other. So that means that you would have a document table, a person table, a company table, and a field table. And so this could obviously get very complex and very large as you had more and more tables that would need to reference each other. What Enfish did was to basically collate all of these tables into one so that the table referred to itself. So you can see here, row number 1 references number 2 for person, and then number 2 row references number 3, which is the company. And so it kind of is referencing itself. And so really minimizes the space and data needed and volume, and really makes it into a very user-friendly, small, compact use for finding data. And what the court found was that they didn't even have to go to step 2A because these claims are not directed to an abstract idea. And so they really stayed in that step 1 and went right to patentable subject matter. And they stated that software can make non-abstract improvements to computer technology just as hardware improvements can. And sometimes the improvements can be accomplished through either route. So they basically thought that this self-referential table was a non-abstract improvement to computer technology and therefore deemed them to be valid claims. And again, improved the functionality of the computer itself. So similar to DDR Holdings, we now have a couple of cases that say if you're improving the functionality of the computer itself or the internet, your claim is very likely may be found valid. Next, TLI Communications versus AV Automotive. TLI Communications had claims directed to a method of storing images based on classification data. So for instance, your images may have data associated with time or location or maybe weather that day. And so you could basically store those images based on that classification data and even find them based on that classification data. And what the court found here was that these claims were cited generic computer components or previously known elements, and they behaved exactly as expected. And so they deemed these claims to be basically applied on a computer. And so this did not weigh in favor, of course, of validity for TLI communications, and these claims are found invalid. And who knows, it had these claims been drafted differently, knowing this would have been the interpretation, they might have included more details that would have helped them clear this 101 hurdle. Next is Bascom versus AT&T. Bascom had claims directed to content filtering located at a remote server. Previous content filtering had to do with more local filtering. That means the computer would have a set of filtering parameters, and that was indiscriminate to who was using the computer. What Bascom was arguing is that you could have a content filtering that was customizable to a user so that you didn't have to have a one-size-fits-all for content filtering. So your kid could have different content filtering versus an employee versus a parent. So what the court found was that there was a very clear problem solution statement in the background. Again, they really clearly defined how content was filtered previously and how their system differed from previous content filtering schemes. And they really sought to solve a problem rooted in computer technology and the use of computer technology. How do you dictate who sees what, when, and make it customizable for all those users so that somebody's not being cheated out of something that they should be able to see and somebody's not seeing something that they shouldn't see. So Bascom was upheld. Next is McRow versus Bandai. These claims are directed to lip synchronization animation software. Previously, they used multiple 3D models of a character's face to depict various facial expressions made during speech. And then basically you would morph that character's expression between those models to create the appearance of animation. What McRow did was basically create software that automated this process using different rules and then applying those rules to automate the lip sync process. So courts found that the claims do not preempt the entire lip synchronization field as was put forth by Bandai, which again is not the sole factor for determining eligibility, but definitely weighs in favor of it. They had a very clear problem solution statement. Again, their problem was that these manual techniques were cumbersome, required many hours of people hours to achieve. And then they clearly laid out how their technology improved existing manual techniques. And the court stated that it was the incorporation of these claimed rules, not the use of the computer itself, that improved the existing technological process. So really clarifying that, again, it wasn't just that they were using a computer, is that they really had a defined way to improve this process. And kind of like similar to Diamond versus Deere, again, they had, it's not exactly the same idea, but kind of, right? They were using algorithm to improve rubber curing processes. In this case, they're using rules to improve another technological process, which is animation. Next is Fair Warning versus Iatrix Systems. So Fair Warning had claims directed to identifying fraudulent access of protected health information by an otherwise authorized user. So this is the idea that a doctor who has access to certain patient data may not have access to all of the patient data, or maybe to other patients that are not currently his patients, but he would maybe be found accessing that data. So what the court found was that it was an automation of old processes in which people detected fraud by asking a series of questions, and it was not a problem arising in the realm of computer technology. And I actually strongly disagree with this opinion, because I think that the whole idea of detecting fraud by asking a series of questions, I think, is a 3,000-foot overview of these claims, and I think unnecessarily makes them sound super generic when maybe they're not. And I also do think this is a problem arising in the realm of computer technology, because how else, if you don't have processes in place to detect when someone is accessing data they shouldn't be in a computer case, how do you detect it without using software systems and methods, right? Because otherwise you'd have to catch them in the act. You'd have to walk into a room where they were sitting on a computer accessing the data, right? You'd have to have some kind of logs and information to determine when it was accessed or how. And so I strongly disagree with this case, and maybe if the claims had been drafted differently, it would have been a different outcome. But I think the courts did a way overgeneralization of the claims here and definitely didn't help fair warning at all. Next is Amdocs versus OpenNet. Amdocs, these are claims directed to a system for accounting and invoicing for IP network communications. And the serious fatal flaw in the Amdocs claims is that they are crazy broad. And so that was their fatal flaw. And again, maybe had the draftsman art been a little bit better at that time, or had they included more details, more features into their claims, maybe they would have had the outcome that they did have. So the outcome that they had was that the court said it was unclear if the claims were directed to an abstract idea, so they skipped 2A and moved to step 2B. And they found that basically they were manipulating existing information to generate additional information. Which again, this is a little bit of an oversimplification of the claims, but here is an example of one of the claims from the patent, and you can see that it's exceptionally broad. It basically discusses using data from a second source to improve or enhance an accounting record. And so it's very, very broad, and had they included more details, it might have not had the outcome that they had. So now that we've reviewed some of these court cases, you probably are already starting to see some of the themes here about how to best put your application in condition for overcoming a 101 challenge. But let's kind of dive into some of these here anyways, and maybe I'll enlighten you still. So specification drafting tips, as we've seen in several of these cases, it really define the problem that you seek to solve. Particularly McRow you saw, or Bascom, they really identified what the problem was that they were trying to solve, and that really weighed heavily in their favor. So what are the limitations of current technologies, and how did your technology solve those limitations? Also state the solution with particularity, including the technical details. Really dive in deep into your technology and really describe it with granularity. And then, if possible, describe how the technology or software solves a problem rooted in computers or the internet. And we saw that in DDR Holdings or in Enfish. This really helped their case, that they were able to prove that it was solving a problem rooted in computers or the internet. Also, describe even those method steps that may be obvious to one of skill in the art. So if you're doing some processing or some analyzing, describe how that's done. Describe what the computer is doing to transform data A into data B, or whatever the case is. Don't be afraid to use complex flowcharts. As you'll see in a Bascom figure I have coming up here, that computers a lot of times don't operate in linear flowcharts. They have complex flowcharts or complex decisioning points. So don't be afraid to highlight that in your flowcharts. Make sure you fill in the black box. Sometimes algorithms or code examples or pseudocode may help. And again, describe words like analyze and what it means and what the computer is actually doing. And describe components and their functions, even including generic computer components. If you're using generic processors or memory, still include what they're doing, because that may help you, at least with some examiners. And if there are any functions that are unconventional, highlight them. And this may require you to really look in depth at your software, at the back end of your software, and what's actually happening, because you may find that you can claim something very interesting about your technology that's maybe not the exactly user-facing side of it, but still may be really important to how your software functions. And this is a little bit what DDR Holdings did. They really focused on the link and how that worked to transport people to this composite website, or generated this composite website. So this is an example of a figure from Bascom from a Bascom patent. You can see it's a complex flow chart, and this is how they did some of their remote content filtering. And this is an example or snapshot from the specification in the DDR Holdings patent, and you can see they talk about various layers of their software, the API layer, the cache layer, adapter scripts, and I think this definitely helped their case, because it really gave them a lot of material to work with in arguing why their claims are valid. Some additional claim drafting tips: include structural elements where possible, even if it's just in the specification. If you're using a specific device, you might as well put it in there from the beginning. What we're finding more and more is that if you have a specific device, you're going to need to probably put it into your claims in some aspect. Maybe you don't have to claim it exactly what it is. It may be somewhat generically, but enough to where it's not viewed as a generic device. But if you are using generic computer components, still put those in the specification and obviously include some of those structural elements in the claim, because that will at least help you argue a little bit that it's not just an abstract idea. Make sure you're detailed. Include steps showing how the data is converted from one state to another, and avoid overly broad claims that may be viewed as preemptive. And again, preemption isn't the only test for eligibility, but definitely if you're not preempting, it weighs in your favor. And embrace complexity in this whole process. If you can conceivably do the steps in your head, rewrite the claim and consider adding more detail to the specification. Because if you can do it in your head, the examiner is certainly going to say you can do it in your head and is going to give you a one-order direction for that. So here's an example of an overly broad claim. This is an example claim from the Andox patent that I described earlier. You can see that they just had severely lacking in detail, which was definitely one of their fatal flaws. In contrast, this is an example, a patent claim from the McRow patent. You can see that they describe very clearly their rules that they're using to automate lip sync, and then how they apply those rules to create the ultimate lip and facial expression synchronization. And so include those details, because that will definitely help you in the long run. So that concludes part 1 of our discussion. Join me for part 2, where we're going to talk about alternatives for protecting software innovations if patenting isn't really going to work for you.